Good morning, everyone. My name is Jared Solomon, Chair of Veterans Affairs and Emergency Preparedness. I'd like to call this joint meeting of Veterans Affairs and Judiciary to order. Kerry, if you could please call the roll for Veterans Affairs.
Chairman Solomon.
Here.
Rep. Borowski, on leave. Rep. Brown, on leave. Rep. Doherty, on leave. Rep. Genst. Rep. Haddock, on leave. Rep. Ingalls, he's online. Rep. Monroe, on leave. Rep. O'Mara, on leave. Rep. Pielli, on leave. Rep. Sappi, on leave. Rep. Scott.
Here.
Rep. Takak, on leave. Rep. Webster, on leave. Chairman Gillen. Rep. Banta. Rep. Bashline. Rep. Cooper. Rep. Ham. Rep. Kerwin. Rep. Krupa. Rep. Major. Rep. Rigby. Rep. Stender. Rep. Watro. Rep. Williams.
Judiciary, please.
Secretary, please call the roll of Judiciary members.
Chairman Briggs,
Present.
Representatives Carroll, on leave. Donahue, on leave. Hanbidge, on leave. Owenstein, on leave. Howard, Kenyatta, on leave. Kincaid, Mays, on leave. Miller, on leave. Pielli, on leave. Rabb, on leave. Sanchez,
Here.
Schusterman, on leave. Chairman Kaufman,
Here.
Representatives Bonner, Borowitz,
On leave.
Ecker, on leave. Ham, on leave. Kale, on leave. Kerwin, on leave. Clunk, on leave. Kuzma, on leave. Ledbetter, on leave. Rigby, on leave. Shalaba. Thank you.
Thank you, Secretary.
Thank you. We're going to do opening statements from chairs. I will first start with Chairman Briggs.
No, I just want to thank the testifiers for being here and Chairman Solomon's suggestion of doing a joint committee on this important topic. I think it'll be valuable for us to hear, and also want to acknowledge Senator Rothman for joining us as well. Thank you.
Good morning, Representative Kaufman, Minority Chair, and I appreciate Chairman Solomon for taking the lead on this and bringing us all together for this important conversation, and the gentleman for making your way to Harrisburg and giving us your expertise. Thank you very much, gentlemen.
Chairman Gillen.
I had the privilege of a preliminary meeting with General McEwen yesterday, very enlightening. Looking for a more elastic testimony today, and pleased to have General Tate and Brock with us, and a friend, Judge O'Neill from neighboring Montgomery County. We have very active Berks County through probation and parole, a Veterans Treatment Court. And so I thank you all for being here. Thank you, Mr. Chairman.
Thank you, chairs. Gentlemen, thank you so much for being here. We are here to discuss veteran treatment courts and adjacent policies and procedures to provide the very best justice for our veteran community right here in the Commonwealth. What we're going to do is each of you will provide your opening remarks, and then we're going to turn it over to members for comments and questions. First, I will go to Major General U.S. Army Clyde Butch Tate, former U.S. Army Deputy Judge Advocate General and Chief Counsel for All Rise. Mr. Tate, please provide your comments.
Thank you and good morning. Chair Solomon and Chair Gillen, Chair Briggs and Chair Kaufman, and members of the House, Veterans Affairs, and Emergency Preparedness and Judiciary Committees, I'm honored to speak in front of you today. At All Rise, we are focused on deploying a comprehensive approach to ensuring that veterans at every stage of the justice system have access to the benefits and treatment that they have earned. This approach combines the appropriate levels of accountability through supervision with evidence-based treatment and includes Veterans Treatment Courts, or VTCs, as I'll refer to them this morning, for individuals with more serious substance use, mental health, cognitive, and criminogenic needs. For the past 15 years, All Rise's division, Justice for Vets, has led the national effort to support VTCs through training and technical assistance. Our work has included program implementation support, discipline-specific and mentor training, and continuous technical assistance, reaching nearly every operational VTC and most of their personnel. The insights and successes gleaned from these courts have helped spur innovations across the justice system, from arrest and booking procedures that identify veterans to crisis intervention training and to the development of U.S. Department of Veterans Affairs justice outreach roles. Veterans Treatment Courts have served as a powerful model for those innovations. When I served as a Major General in the U.S. Army Judge Advocate General's Corps, I saw countless examples of the unparalleled honor, sacrifice, and resilience of members of the military. I also came to understand the many ways in which our service members can have difficulties transitioning to civilian life, and how, despite a myriad of local, state, and federal benefits and support, some fall through the cracks and become involved in the justice system. But we also understand that too many veterans are impacted by substance use, mental health, and neurocognitive disorders, issues closely associated with involvement in the justice system. In 2014, as my retirement after 31 years of service in the Army drew closer, I found myself searching for some way to remain involved in supporting our military and veteran communities. Around this time, I was invited by the nonprofit All Rise to attend a conference on VTCs. The conference closed with the swearing in of over 50 volunteer veterans who that week had trained to serve as mentors in VTCs. Pride and dedication to the mission of recovery was evident on their faces as they pledged to be of service to veterans in need. I learned that VTCs were just one of several treatment court models that address substance use, mental health, and crime with greater effectiveness than any other strategy. The experience left a profound impact on me, and I knew I wanted to be involved. And for the past 8 years, I have been honored to have a small hand in this impact as Chief Counsel for All Rise. Veterans Treatment Courts have proven that the justice system can play a vital role in improving outcomes for veterans coping with substance use, mental health, and neurocognitive disorders. These courts are modeled after drug courts, the most effective justice system intervention for individuals with substance use disorders in our nation's history, and have grown substantially in number and impact. Today, there are over 4,000 treatment courts across the United States, including more than 500 specifically designed for veterans. To fully understand these programs, it is essential to grasp 3 things. First, who VTCs are designed to serve. Second, why they are so successful. And third, how they inform the development of other justice interventions for veterans who may not meet eligibility criteria for these programs. VTCs are intensive programs that pair close supervision and accountability with robust, evidence-based treatment. Research consistently affirms that these courts are most effective when they focus on veterans assessed as both high risk and high need. Now, importantly, high risk does not refer to a threat to public safety, but to a higher likelihood of poor outcomes in standard community supervision or treatment settings, often associated with extensive criminal histories or antisocial traits. High need indicates a clinical assessment identifying severe substance use or mental health disorders, neurocognitive disorders, and pressing social needs such as homelessness and unemployment. While some may believe that VTCs are for every veteran in need, VTCs are instead intended for and work best with those facing the most complex and severe challenges. To determine where a veteran falls on the risk-need spectrum, They are screened for possible clinical issues and assessed to determine crimogenic risk and need levels. This standard practice in VTCs is foundational for any system seeking to place veterans in alternative programs that blend the right mix of supervision and treatment. While many VTCs accept veterans with discharge statuses that restrict or eliminate their VA benefits, bad paper, in other words, it is important that these programs develop partnership with veteran-specific treatment providers in the community to ensure that those veterans have access to the treatment they need. Now, to be sure, Justice for Vets encourages broad eligibility when it comes to discharge status. While VTCs adhere to evidence-based standards and serve the appropriate population and receive ongoing training, they are proven to reduce recidivism, enhance treatment outcomes, and save taxpayer dollars. These programs also foster improvements in housing stability, employment, and financial security, all strong indicators of lasting rehabilitation and reintegration for those who have served. The success of VTCs lies in their collaborative approach. Judges, prosecutors, defense attorneys, probation officers, and law enforcement work in concert with treatment providers, VA and Veterans Benefits Administration staff, and trained volunteer veteran mentors. Veterans' progress is closely monitored, and interventions are adjusted in real time based on their behavior. The inclusion of trained volunteer veterans as mentors provides essential peer support and camaraderie, reinforcing each participant's sense of identity and connection. Additionally, research shows that outcomes improve by as much as 25% when courts receive specialized training and technical assistance. Now, despite the effectiveness of VTCs, it is essential to ensure that no veteran is left behind. While VTCs are best suited for high-risk, high-need individuals, not every justice-involved veteran is appropriate for the VTC model, but they still require support. Those who don't meet the clinical or criminogenic thresholds for a VTC will typically achieve better outcomes in other programs that align treatment and supervision to their specific needs. A critical first step is universal screening and assessment at all stages of the justice system, from initial law enforcement contact through re-entry and community supervision. These screenings help identify veterans, evaluate clinical and criminogenic needs, and guide decisions about supervision, treatment planning, and diversion opportunities. Moreover, these assessments are essential for identifying individuals at heightened risk for suicide, overdose, thus enabling courts and agencies to respond swiftly and potentially save lives. Finally, we applaud the care with which the Pennsylvania legislature is exploring a comprehensive approach to veterans in the justice system. All Rise stands ready to support the Commonwealth in the critical mission of ensuring that veterans receive the opportunity for transformation and restoration that they have earned. Thank you again for the opportunity to appear before you today.
Thank you so much, sir. Next up, we have Brigadier General, U.S. Army retired, David Mack McEwen. He is the Director of the Veterans Justice Commission at the Council on Criminal Justice. Sir, please proceed with your comments.
Thank you, Chairman Solomon, Chairman Briggs, Chairman Gillen, Chairman Kaufman, and other members of the committees for inviting us to speak on this topic. I'm Mack McEwen. I'm a 33-year veteran of the United States Army, born in Pennsylvania, son of a veteran, grandson of a veteran from Pennsylvania. I'm here representing the Council on Criminal Justice. I serve as the Director of the Veterans Justice Commission, and I'm grateful for the opportunity to share the work of the Veterans Justice Commission and its policy recommendations, because I believe these findings and recommendations can impact veterans across the Commonwealth. That impact can be life-changing for many, and I appreciate your consideration of what we have to say today. The Council on Criminal Justice is an invitational think tank. It's independent and nonpartisan. Our mission is to advance the understanding of the nation's criminal justice policy choices and build consensus for solutions rooted in facts, evidence, and fundamental principles of justice. In 2022, the Council assembled the Veterans Justice Commission to assess the risk factors that drive veterans' justice system involvement, the adequacy of transitional assistance for military service members as they re-enter civilian life, and the effectiveness of the justice system's response when veterans break the law. Led by two former Secretaries of Defense, The VJC included 13 other leaders in science, the judiciary, the recovery field, healthcare, corrections, law enforcement, Veterans Affairs, and the military. The VJC issued 3 reports that included 11 findings and recommendations, and several of those are relevant to today's hearing. Studies show that service-related trauma exposure combined with increased incidence of mental health and substance use disorders elevates veterans' risks of involvement with criminal justice. Veterans who have served in the military since September 11, 2001 may especially be at risk, in part because they've seen more combat deployments and redeployments than any other previous cohorts of service members. The recommendations for evidence-based policy changes that enhance safety, health, and justice. The VJC found that reliable estimates of how many veterans are currently incarcerated or have come in contact with the criminal justice system more generally do not exist. The lack of knowledge is this product of several interrelated complications. First, criminal justice agencies and courts tend to rely on individuals to self-report their veteran status. Studies show that when asked about their status by law enforcement, many former service members are hesitant to identify as veterans. Some worry about losing benefits, while others report feeling of sense of shame or fear for being viewed as a threat. The Department of Veterans Affairs has created tools, 2 databases called Squares and VRSS, that allow law enforcement, jails, and courts to independently verify the veteran status of individuals. But usage of these systems is extremely low. Further complicating the identification challenge is an inconsistent definition of the term veteran. Federal and state statutory frameworks and regulations use different definitions. Among those frequently excluded from eligibility for benefits are individuals who receive administrative, other than honorable discharges, or punitive bad conduct discharges, often grouped together under the characterization of bad paper discharges. This exclusion presents a challenge for an increasingly large portion of American veterans. The VJC recommends that federal, state, and local criminal justice agencies and courts should improve processes for identifying veterans in the criminal justice system and adopt a uniform definition of military veterans for those processes. Also, the Commission recommends that Congress and states should incentivize the use of the VA databases by state and local law enforcement officers, jail staffs, and court personnel by requiring adoption and implementation of the systems before certain funds and other resources can be assessed. The VJC study concluded that veterans who commit offenses as a result of service-related conditions represent a unique class of defendant in our criminal justice system because the conditions of their underlying criminality are partially created by the government who prosecutes them. Research demonstrates an association between combat exposure and negative behavior outcomes suggests that America sends its men and women to war with an understanding that some, not all, but some will bring war home with them in the form of criminal conduct against fellow citizens they once fought to protect. The VJC assessment revealed the veterans treatment courts have become a popular approach to diverting veterans from incarceration in favor of treatment. But the 600 such courts currently operating in the country, and even with a particular state, vary widely in their approaches of eligibility and legal incentive. For example, a national survey of VTCs found that nearly 60% of VTCs exclude veterans with at least one type of violent felony charge, while 35% do not permit veterans with bad paper discharge. The Commission found 12 states have created post-conviction statutory schemes separate from VTCs that recognize veteran status as a mitigating factor in sentencing. Many of these statutes, however, are now antiquated in that they don't take in sufficient account of mental health considerations and do not allow the veterans the opportunity to avoid a conviction record. The VJC recommends that states codify their rehabilitation best practices for justice-involved veterans into statutes that cast a wider net and provide more alternatives to incarceration and prosecution. Such laws ensures that all veterans have access to rehabilitation interventions, sentencing mitigations, probation or parole considerations, when appropriate. The recommendation is best exemplified through the model policy framework authored by the VJC Committee. The MPF calls for state statutes that permit courts to take veterans' national service and military experience into account at sentencing, and create or expand judicial diversion and deferred adjudication program that incentivize veterans to take responsibility for their action and to help them resolve the issues underlying their criminal behavior. The Model Policy Framework, MPF, would expand intervention opportunities by adopting a broad definition of veteran and include veterans charged with felonies in most crimes, except those that would require predatory offender registration, as well as veterans who are not eligible for a VTC. Other key elements: ensuring judges retain discretion to decide eligibility in individual cases, offering strong legal incentives such as early termination of supervision and case dismissal to encourage veterans to complete the individual case plans and avoid collateral consequences of a criminal conviction. Clearly define individual behavioral goals that veterans must meet to successfully complete the programs, including restoration of victims and survivors. Allow veterans to transfer supervision to their county of residence. Ensure opportunities for victims, survivors, and family members to be involved in the supervision and treatment process, including the opportunity to be heard at final case dismissal hearings. Notably, the MPF inspired both ALEC, the American Legislative Exchange Council's adoptions of the Veterans Justice Act in 2023, and a policy brief by the National Conference of State Legislators in 2024. The Nebraska legislature passed a law last year that was inspired by the MPF and mirrored its key elements, and it will be implemented in 2027. Currently, no lawmakers in other states who are considering adoption of similar policy. Studies show that deployment-related trauma exposure combined with increased incidence of mental health and substance use disorders elevate veterans' risk of contact with the justice system. Once ensnared by the system, veterans often present a complex set of needs and risk factors that are distinctive from those characteristics of civilians without a military background. These policy recommendations are designed to advance public safety by ensuring veterans get the therapeutic interventions they need. It's nothing short of tragic that some men and women who wore the cloth of our nation are now wearing the cloth of incarceration. People who have served this nation through service in our armed forces have sacrificed to protect us. It's time to better recognize their service and take steps to ensure that our veterans are not lost in prison and jails, but instead receive the interventions that can help them resume their responsibilities to their families, their communities, and their countries. These individuals can be restored to become an asset to families and communities, but we must acknowledge the scars they bear from fighting for us and help them heal. We must do better. We must not leave them behind. Thank you.
Thank you, sir. Next, we have Mr. Brock Hunter, Esquire. He is a Veterans Criminal Defense Attorney for the Law Office of Brock D. Hunter and advisor to the Veterans Justice Commission for the Council on Criminal Justice. Sir, please begin.
Thank you, Chairman Solomon, Chairman Briggs, Chairman Gillen, Chairman Kaufman, and other members of the committee for inviting me to testify here today. As noted by Chairman Solomon, I am an attorney and I am a former U.S. Army Scout, and I focus my law practice on defending fellow veterans in the criminal court system. I also conduct policy advocacy through a nonprofit, the Veterans Defense Project. I'm here today representing the Council on Criminal Justice and the Veterans Justice Commission, which I have advised since its inception in 2022. I've also previously served on the board of All Rise, specifically serving as the chair of its Veterans Treatment Court Committee. I'd like to start my remarks by noting that for as long as veterans have returned from war, most have returned home stronger and wiser from their service, immediate assets to their communities. Some, though, have always brought their wars home with them, bearing invisible wounds that today we call post-traumatic stress and traumatic brain injury. Untreated, these echoes of war manifest in self-destructive, reckless, and sometimes violent behaviors that reverberate through society, not only destroying the lives of these veterans, but impacting their families and the very communities that they serve to protect. In this way, large numbers of veterans in past generations have fallen into and been left behind in the criminal justice system upon their return home. Over the past 20 years, our modern generation of veterans have been returning home from our wars in Iraq and Afghanistan and elsewhere. And there is good reason to believe that more of them will bring their wars home with them than any previous generation. This is our most heavily deployed generation of veterans in our nation's history. Without the draft we've relied on in past conflicts, this generation has been relatively small, yet have fought the longest wars in our country's history simultaneously. We've only sustained these wars by redeploying our veterans over and over again in a way we've simply never done before in our history. And these multiple combat tours, studies show very conclusively, lead to higher rates of post-traumatic stress and higher rates of involvement in the criminal justice system. Whereas the majority of Vietnam veterans served one 12-month tour, veterans of our modern wars have commonly served 2 tours, 3 tours, and sometimes many more. Within my practice, our current record is a client who served 13 combat tours with Army Special Operations. And he humbly notes that he is nothing special in that world. He has friends still serving who are up over 20 combat deployments post 9/11. Again, our most heavily deployed generation by far. Furthermore, this generation of returning veterans is also the most lethal in our country's history. Having honed their modern and very sophisticated combat training, often over multiple combat tours, they pose a unique public safety risk if their trauma goes untreated and they're not properly reintegrated back into their communities. The rise and growth of veterans treatment courts has been a welcome response to this crisis. Their approach holds a promise to help seize the opportunity for reintegration and redemption. As General Tate testified, though, veterans treatment courts are not a one-size-fits-all approach. They are best suited for high-risk, high-need veterans, and all too often there are no other alternatives to veterans treatment courts, even in the jurisdictions where they exist. Perhaps more importantly, though, veterans treatment courts only exist in a small minority of jurisdictions, and this is not just true here in the Commonwealth, but nationwide. I believe only 15% of jurisdictions in the United States have a veterans treatment court. Here in the Commonwealth, 25 of the 67 counties have veterans treatment courts, so the majority of veterans in the majority of jurisdictions have no access to a therapeutic intervention. And as noted by General McEwen, the eligibility criteria for veterans treatment courts vary widely from court to court, depending on what types of offenses they take, what types of discharge veterans can have. Even where courts exist, the majority of veterans coming through those jurisdictions do not have access to the veterans treatment court. And because of all these reasons, far too many of our veterans coming through the justice system are falling through the cracks. We are missing critical intervention opportunities with each and every one of them. We can't leave these men and women who served and sacrificed on our behalf behind. The Commission's model policy framework that General McEwen talked about would allow Pennsylvania to address the needs of far more veterans because it creates standardized sentencing options for judges in all Pennsylvania jurisdictions to maximize the intervention opportunity presented when a troubled veteran falls into the justice system. Instead of relying on local policies like prosecutors' diversion and widely varying eligibility criteria of veterans courts, a statute based on the MPF would send a clear message across the Commonwealth. The public policy of Pennsylvania is to recognize the scars that accompany military service and maximizes the number of veterans who can be offered treatment interventions so that they can return to their communities stronger and more resilient assets, just like the other veterans who came home stronger and wiser from their service. This VJC recommendation for the model policy framework is complementary to other existing veteran interventions like VTCs and prosecutor diversion programs. They provide accountability, supervision, individualized treatment in jurisdictions that don't have a VTC or diversion program, and they serve as an additional intervention tool in jurisdictions that do have such programs. Veterans found eligible under the MPF framework would receive an opportunity to avoid a criminal conviction, a powerful incentive for veterans to take responsibility for themselves, to hold themselves accountable, to complete challenging treatment programs, to bridge the divide that all too many veterans feel between themselves and their own communities, and to once again restore their honor and become assets to the communities rather than ongoing liabilities. In this way, Pennsylvania can better honor their veterans' service and better protect public safety in both the short and the long term. Thank you for your time.
Thank you, Mr. Hunter. Last, we have Judge Stephen O'Neill. He is a judge for the Montgomery County Court of Common Pleas. Judge, please take it away. Thank you.
Thank you, Chair Solomon.
Your mic, please, Judge. Thank you so much.
But you can give Greg and I extra attention.
Again, Representative Briggs, Representative Scott from my county, again, Representative Scott. The approach that I'm taking, he saw what it was like on the ground. We've heard these very respective and experienced members testify as to what is the overall issue. And the priority is clear. How can we best serve those who served us? How do you do it? On the ground, it's tough. It's tough because we're talking about substance use and mental health issues, which I believe is my role here to talk about what are the successful interventions that we find with those in our criminal justice system who suffer mental health and substance use disorders. And a traditional justice system was never set up on how to handle those issues. That's partly how treatment courts were begun back in 1989, of all places, Miami, Florida, and at the time they were having a cocaine use disorder, back formerly known as addiction issues, that needed intervention from courts who were in a position to actually use their power and the opportunity of someone in the criminal justice system to make a difference, to bring together science, compassion, and traditional criminal justice to be able to change outcomes. That's what we're here for. So, treatment courts, without a doubt, of which veteran treatment courts and all the principles, the best practices that work with those types of populations, mental health and substance use disorder, treatment courts have found the most effective way and therefore are the most successful intervention in the criminal justice system ever. Why? Because you're simply treating the underlying issues as opposed to trying to incarcerate them away or dealing with what I call the symptoms of these mental health and substance use, which is incarceration, and the last time I was testifying before a committee here, death by overdose. Those are the two things that don't go away. They get replaced in the headlines by various things, but overdose is very real. It's and overdosing and coming into the criminal justice system is how most of them get in there with the crimes that are associated with their substance use disorder and mental health. They're traditionally the crimes of theft, driving under the influence, possession, burglaries, the types of crimes which we know to be symptomatic. So I've been a common pleas judge now for 23 years, and it was early on through my experience. I was an assistant DA and I was in private criminal defense. I saw immediately there was something going on here. These were not simply bad people entering into a justice system. These were good people struggling, who, because of their substance use and mental health disorder, found themselves in a criminal justice system. And when that occurs, what are we going to be able to do for them? Not just truly out of the empathic approach to say is, look, they're struggling. We wouldn't do it to people who suffer, other relapsing disorders of the body. Why do we think it's okay to think we can incarcerate it away? Where we know our jails do not deliver treatment services. They can offer medication to assist treatment, but they do not provide them in the jails. And when someone gets locked up, they're back out on the street without a probation system designed to deal with the specialized disorders of mental health and substance use. So I said, well, how can we? I started to look around, and I found All Rise. All Rise, formerly known as the National Association of Drug Court Professionals, have been studying it since the inception in 1989, and we're finding out that, hey, the courts present a unique opportunity because of the power and the authority of the judge in the system, and combine that with the delivery of treatment and recovery services, we make a difference. But not just the anecdotal difference that we can talk about before legislative and investigative bodies. We're talking about real outcomes, the kind of outcomes that now, again, I'm here on behalf of the AOPC, our Supreme Court, our AOPC Office of Treatment Courts, which do the job of studying it, gathering the data. My 23 years in Montgomery County, I've been collecting the data. As I note in my notes here, again, I started a treatment court in 2006 because now I felt I was in a position. I had trained, I had understood what are these things called key components and best practices. They're simply evidence-based practices, things that work when you're going to treat these two types of disorders. And I, with the support of our county commissioners, which was incredible back then, they simply said, well, you certainly talk a good game. Here's money. And they gave me $600,000, which back in 2005, when they authored it, was a pretty extraordinary sum. And I'm going, I sure hope I know what I'm talking about. 20 years have borne me out to say, yeah, we do. We know what we're talking about. Drug court begat to our behavioral health court. That was to begin to deal with the mental health disorders that are in the criminal justice system. That begat our veterans treatment court. We say we owe a duty to them, not to say here's an easy way out. We'll divert you out because you're a veteran. We're saying, hey, we know about trauma and trauma as a major risk factor in, obviously, mental health, but more importantly, substance use disorders. Here we have courts, so we know what we're doing. We opened our vet treatment court, and then that was followed, again, by, during the overdose crisis, a targeted opioid phase, using the power of the courts and science and what we know about recovery to address it right there on the ground. And it finally is about to begin in our county, a family dependency treatment court to begin to make a difference. But back to why do treatment courts work? Well, we know, we've studied them, and the data which I've supplied in my notes here, we have 129 treatment courts in this Commonwealth. That's a lot. We stand out in this country with how treatment courts have advanced in this Commonwealth. We have 25, 27 veterans treatment courts, and with the help of the AOPC, we've learned how do you bring a veterans treatment court into a more regional system, which are rural areas. You bring them in as regional treatment courts. The DUI courts, what we call hybrid courts, the mental health courts, the family treatment courts, the juvenile treatment courts. This is a system now that we can begin to study through the AOPC and with data. It's unquestioned that treatment courts work. They change outcomes. It's just a simple fact, what I know in my county, we've had 856 graduates of our treatment court over the years. And there's the anecdotal stories about interrupting generational cycles of addiction and substance use in a family, and the drug-free babies that are born, and the reintroduction into society of people, which we would like to say are, substance use disordered individuals who have a criminal justice problem, not criminals who have a substance use disorder or a mental health problem. And that's all about how do you look at the individual before you as a judge. So we find out that the outcomes, that normally if you introduce somebody into a justice system and don't do anything for them and have them on a regular probation track, we're just not prepared. Probation's not about treatment, and the supervision isn't about being able to supervise someone in recovery. It takes a lot of time, but it takes a whole lot less money than incarceration. To incarcerate somebody in Montgomery County costs about $20,000 a year. Treatment court averages about $8,000 a year. It's a long program. It's all based upon this. Best practice standards, constantly updated, constantly studied by All Rise, so that we have the latest data to know exactly what works. So people like me don't just sit up and tell those in power to make a difference, well, we just want your money, we want your support, but we can't show you outcomes. So I've put those best practices, what does work, in my notes. We know that what works. Where does the veteran in the criminal justice system fit in a treatment court scenario? They're part of it. If treatment courts are the most successful, that's why the counties that have the ability, that have the providers, that have that intervention, start veterans treatment courts. We know that the first and most important thing is how are we going to identify veterans in the Commonwealth of Pennsylvania? It was a question I was asked before I gave these remarks, and I found that in our Common Pleas case management system, they're right there. It's done from the ground up. There's a little veterans icon that's there for every single person who's in the criminal justice system. If they're a veteran, we know about it. I found out, okay, how do we collect this information? It was made a priority for the input. So we have the ability as a justice system to identify our veterans. Question is, what are we going to do with them? If a veterans treatment court represents just simply one component that we know works, then obviously those who are qualified, we need to get them in. I agree with my fellow declarants here that how do we identify the appropriate veteran for our veterans treatment courts? That's the issue. That's partnerships with district attorney's office to decide that, again, the veteran who have their own unique set of problems coming into a justice system need to be identified, and they need to be viewed to put them into the most beneficial and best outcome for their substance use disorder or their mental health issue. So that, again, I go into some suggestions there, but don't get hung up on the definitions of a veteran. If they say they're a veteran and we know that there's nothing to hang them up within some of the criteria that these gentlemen talk about, let's get them into the system. What happens when we can't get them into the system? We do, as I have found out, we have in Montgomery County, we can begin to deal with unique and pressing issues, which are the veteran in crisis. We're the first county to have a veterans treatment response team. That is where we train law enforcement. Started out with law enforcement who are veterans to be able to deal immediate in crisis situations, which when you're talking trauma, those are how they present into a system. And sadly, too often, that trauma presents into a system, into a crime that gets them into the criminal justice system. So, look, I have to make these remarks quick about something that I'm very passionate about and that I know works. But I do see in the future to treatment courts that very good legislation around probation reform can lose the opportunity, and that's what treatment courts work on. Opportunity and the right mixture of treatment and diversion into a system that lasts 18 to 24 months in some case. That's how long treatment takes. We don't pretend that mental health disorders and substance use disorders happened overnight or happened in 30, 60, or 90-day intervals, which were the traditional intervention for a treatment. You know, I'm fond of saying, look, inpatient treatment is great and we support it as part of a long-term recovery, but you might as well give them the same amount of money, go to Disney World, enjoy themselves, because you're going to have the same outcomes with short-term focus on the long-term issue of recovery. So what happens is those who are in our probation and parole systems, look, I fully support Act 44 and what it intended to do, but it needs to have treatment courts as a priority in there. You want to be able to lessen your period of time, do treatment courts, get into treatment courts. We are built out now in this Commonwealth where we can handle it, but we are now all, and I speak for most judges, we're seeing the decline now that Act 44 has kicked in. The Supreme Court in their Shiflett decision has changed DUI. DUI is a major driving force for those with substance use issues in the Commonwealth. Why do they come into treatment courts? Because they don't want to go to state prison. They don't want long-term county prison, so they'll do anything to avoid that. In our business, we call that opportunity. That's the window. That's where we need to meet them. If we create systems where they're not going to be in jail, or their probation's never even going to set them up because we have probation violation systems that don't push them towards a treatment court, we will have further decline in systems that we know work. So I apologize if I have gone over. As you can tell, I'm passionate because I know how well they work. And again, I do this because I care about what we do, this idea of making a difference. I, over the last 20 years, have been able to live that every single day. I've done 187 graduations, and I do each one of them. And that speech that I put in there, when I talk about it, it's the passion that I think what we, I'm entreating all of us, our legislative branch, our executive branch, and our judicial branch, to serve those who served us and serve those who are in need. Sorry if I went over.
Thank you,
Do it all
Judge.
the time.
Appreciate it. We have a little wiggle room with session, maybe about 20 minutes for questions and comments. Members, comments, questions. Representative Ecker.
Thank you, Mr. Chairman, and thank you for the testimony. This issue is something that has been brought to my attention. I've represented, as an attorney, I've represented in counties that have treatment courts and don't have treatment courts. In fact, where I live in Adams County, we don't have treatment courts, and especially a veterans treatment court. And I've met with various constituents saying, why don't we? So I've met with our president judge, and one of the things he talked about, not that he's against the treatment court, but he's talked about as a judge, he has the discretion to pretty much do what treatment courts do anyway. I'm curious from your, and I'm there advocating for a treatment court. From your perspective, what do these courts, especially this veterans court, give tools and toolbox? Judge, obviously you do this day to day. What tools does this give you that you wouldn't otherwise have as a judge or court?
I'll take that on initially, if it's okay with my colleagues. The courts are given, as has been mentioned before, the best practice standards. The evidence shows that complying with those standards, and I commend the Commonwealth for adopting those standards, has been proven to lead to improved outcomes for the veterans. So there are so many resources available for every judge to turn to for free and figure out, how do I construct my court? Because if you don't construct it properly, you have a court for veterans and not a veterans treatment court. And so there is what I would suggest, a better way to do this, and that is to follow the standards, to have mentors present, to provide that, if you will, battle buddy for every justice-involved veteran. So there are a significant number of tools available for the judge who wants to go this route, so much more than when Judge Russell in Buffalo started the first Veterans Treatment Court in 2008. And I'll just say we are a sharing community with tons of information. So the resources are there. It's a matter of having the time and the energy to take that on. So I hope that addresses some of the question. I think importantly, the key should be to provide that continuum of services to improve the outcome for justice-involved veterans. A Veterans Treatment Court is a proven model that will get after the high-risk, high-need veteran, and if that's not appropriate, if they don't need that level of supervision, that level of accountability, then there are other options to include the Veterans Justice Act, which we have said is a model policy that can be used to address those needs.
And if panelists can just be as concise as possible so we can get to as many questions as we can. Thanks.
Thank you, Chair Solomon. Representative Eckert, I would just add to General Tate's comment by indicating that I think the model policy framework, one thing that it would change is it would empower judges to offer veterans coming through the system uniform legal incentives for their participation in a therapeutic intervention, not relying upon the discretion of prosecutors from jurisdiction to jurisdiction, which we found vary greatly.
Sure.
And that this would provide the judges with a toolbox that they don't currently have under the current laws.
Yeah, and thank you, gentlemen, for being here. I support 100% what the treatment court, and I think it's a great idea. Thanks for highlighting that today. Appreciate it. Thank you, Mr. Chairman.
Thank you. Representative Bonner. And if members can also be as concise as possible with their comments and questions.
Thank you, gentlemen, for appearing here today and for your service. Last year, the Pennsylvania Senate passed a resolution directing the Pennsylvania Sentencing Commission to study the issue of veterans courts. And I don't know whether you're aware that that study is ongoing at this time, and a report is due in September of this year. I serve on that committee that is studying veterans courts in Pennsylvania at this time. And one of the issues that we are at least discussing, if not struggling with, is what you view as the eligibility for those who commit violent offenses to be diverted into the treatment courts, and what role, if any, do you foresee for the victims of those violent crimes to participate in that process and object to those proceedings? So we're looking at that issue right now and wondering if you might have some guidance for us on that issue.
Chair Solomon, Representative Bonner, it's a great question, and it's a critical question in this area. We recognize that a therapeutic intervention is just simply not realistic or feasible for the most serious of violent offenses, murder, criminal sexual conduct, etc. But what we found over decades of experience working with veterans in the justice system is that even many veterans who commit violent offenses are redeemable, are absolutely susceptible to an effective therapeutic intervention if it is done properly. And as we've often pointed out, there's veterans who are committing violent offenses in their communities and within their families that pose the greatest risk to public safety, who are having the greatest amount of problems related to their military service and are most in need of a therapeutic intervention. So giving them that opportunity is not giving them a free pass. They have to be held accountable. They have to do what's expected of them. But if it's successful, we found over and over again, they too can be assets rather than liabilities to their communities, and we're better protecting public safety in the long term.
What about the role of the victim, though, who would come forward and object to a veteran entering into the veteran court system?
I think the victim always has a role in his or her case. She or he is the case. We've not taken a stand on what that role might look like. I think that's probably the best purview for the state to take on, but I'll simply say I think they always have a role in how their case proceeds forward.
Thank you. Thank you, Representative. Chairman Briggs.
Thank you, Chairman, and thank you all for being here. It was really insightful. I just want to kind of dovetail what Representative Ecker was saying regarding Adams County. I'm confident that Adams County will address that soon, and maybe we have someone who could take the lead on it next year. But Judge O'Neill, you mentioned the regionalism approach. A number of counties don't have their own veterans court, but do you know kind of ballpark how many participate in another? I just was looking at a list that Mr. Wachter shared us last year. I think 33 counties that have less than 3 judges in their common pleas. So we have a lot of small counties, and I was glad to hear that there was some regionalism effort that could be involved, that we could take advantage of. If not, we can talk
Currently,
offline.
it's Blair, Center, Clearfield, Clinton, Huntington, Juniata, Mifflin, Perry counties. So they're the regional, and again, any type of regional court's going to have to be centered around, where's the Veteran Administration located for the delivery of the services, both ancillary services and direct treatment services. But again, I credit the AOPC. They saw that issue. And again, you can't have a veteran treatment court in a county that has one judge, or as they like to say, more deer than people. It's not going to be feasible to do so. So they are working. Just a note to the victim. This legislature has passed over time very robust victims' rights acts. We're currently, just a recent one came in, and the district attorney has obligations in regards to contact, and any move to diversion or anything else, the victim has been consulted, and surprisingly, the number of times they support the veteran entering into a treatment court.
Great, and it's proud to also have Montgomery County resident Representative Nancy Genst with us. You mentioned Greg and I, but it is great that Montgomery County once again is a leader in this space. We're proud to represent Montgomery County. I'm sure our colleagues are tired of us talking about how proud we are, but thank you for taking the lead on this. It's great.
Thank you, Chairman Briggs. Representative Scott.
Keeping up with Montgomery County, do want to acknowledge my colleague, Representative Webster, here, and Representative Sanchez, who had to leave. We're incredibly proud of the work that you're doing, Judge O'Neill, and our entire bench. And so, as a former district judge, I've seen firsthand the work in your courtroom, the treatment work, outside of the hours of 9 to 5, on weekends, on Saturdays, Sundays, going out in the field. We're incredibly proud of your service over 20 years in the judiciary system. As a person who has seen firsthand what addiction can do, as a child of 2 addicted parents, as relatives that have had addiction, it was gratifying to see someone that looked at folks and not judged them based upon their illness or their worst part of their day, but saw the hope and prosperity that they could bring to the community. So really do want to say, one of the things I do want to lift up for folks that I heard from you today, but also witness and practice, is just the level of awareness that these programs exist, treatment programs. As you all noted, best outcomes start when we get them early. As an MDJ, I had it on my bench, had it a part of my bail, when setting bail, had it a part of my arraignment process, every preliminary hearing, because we shared arraignments. Getting them in early is incredibly important to all of my colleagues who may know of people that could benefit from these programs that are in your respective districts. Let them know about them early on so they can get the treatment they deserve. One other thing I would like for you to address, Judge O'Neill, is some of my colleagues, when I had conversations even about this yesterday, is they say, oh, they get a slap on the wrist. There's no level of accountability. You said it yourself that people will choose the program instead of going to Phoenix, right, or somewhere else. Can you talk about the level of accountability that is in here and the outcomes that come when we have folks that come out of treatment court versus just sending them to a prison and the recidivism rate?
Yeah, I mean, it's just one of the approaches. Obviously, accountability is something that is very difficult for someone with a substance use disorder or mental health disorder, because accountability doesn't work. It can't coincide when you're active in your addictions. The problem is because treatment courts have a long time, we're broken down into phases. So we expect people who come in, we don't expect people in a first phase, first 2 or 3 months, to suddenly stop using these very, very powerful opiates and the like, to just stop. It's a brain disorder. It's a reward system, disorder, so they don't stop. But accountability is built slowly, where they begin to identify, at least with the recovery community that they're exposed to in a treatment court. That starts with the judge. We don't call officers probation officers anymore. We call them treatment officers. We partner with community peer support, so they're not limited to typical AA, NA, spiritual connected. There's many peer support, job training, all the different things go there. So accountability begins to come with it. It just takes time, and by, we work this phase system, they don't move to other phases until the things we call proximal and distal. Proximal are the things that you can deal with right away. Honesty is one of the things, no matter how bad your disorder is, you can deal with. But, that's a proximal goal. A distal goal is the actual being able to lessen and then be able to cease using, the substance that got them there in the first place. So very Skinnerian behavioral, but these best practices show that's exactly what works. Our mind hasn't changed much from over time. It's a reward system, so the accountability comes over time. And they love it when they have it. They feel that they are completely transparent, and that's a real goal for early phases of a program.
Thank you. Thank you. Representative Webster.
Thanks, Mr. Chairman, and as the fourth Montgomery County guy on this side, so we obviously have the
I've been out of
majority
politics a
here,
long
right?
time.
No, I'm teasing, but sort of proud that Montgomery County is so well represented. I also wanted to acknowledge the military service and leadership on the panel as well, all the three gentlemen doing that. My question, I think, falls to Judge O'Neill first, but then broadly. I'm familiar with a local group in Montgomery County called Vets Helping Veterans. And I think that relationship was sort of interrupted with COVID and the different things that happened. At least the last time I was informed, the system that when a veteran was in Veterans Court, they would at least be encouraged or introduced to an outside veterans group to provide one additional amount of service or support. And I think that's been interrupted. I don't know that it's been reconnected. So I wanted to sort of ask that specifically about Montgomery County, but then maybe to the panel about how important it might be to have a veterans organization or Vets Helping Vets as another part of the process.
That's a key component, and we follow that. The vets do better with vets. That's clear. And I'll let these gentlemen speak to why that works. But again, the other main ingredient is the veteran mentor. And that's where these groups feed the mentors into our system. We have an excellent veteran outreach service from the Coatesville Hospital. So yes, it is part of it. We just need to keep expanding it.
Well, and Judge, specifically, if that's something I can help reintroduce. Like I said, the last time I spoke, I know they do Wednesday nights in a church hall near my house, and when I stop in, that's one thing they've asked a couple times, that they don't seem to get the referrals as they used to. So if I can help reconnect that, let's follow up. But yeah,
Sir, I'll just add one point, and I'll get on my soapbox, but Mr. Chair, it'll be very brief. These Veterans Treatment Courts are the judiciary, the community, and the government at their very finest. All three merge together to develop and devote services to the veteran in need. One of those entities, one of those factors, of course, is the community. Community partners are so critical to the success of Veterans Treatment Courts, VSOs, housing authority, housing charities, et cetera. All the community partners who really work hard every day to make life better, a critical element. Thanks for bringing that up.
Thank you, Representative. Representative Krupa.
I want to thank you all for your service and for your advocacy on this issue. And Your Honor, I love your passion. It's very clear. So it's been a few years since I've represented anybody in any of the treatment courts. But one of the things that I found as a real practical matter, there were more incentives, particularly with somebody that may be a first offender who may be ARD eligible, that really, from the attorney's perspective, you can see, hey, this person is suffering from, but I guess as a lay attorney, I can't give any type of medical diagnosis, but it seems apparent that they may have some PTSD issues or something else going on that they could really benefit from what the treatment courts provide. What incentives can we be providing? And this wasn't Veterans Court, it was the Drug and Alcohol Court. I had a client that opted not to do that because she wanted to maintain control over what medicines that she was going to take. So what can we be doing on the legislative branch to incentivize participants who have easier options to them, particularly when they're first-time offenders? And I really appreciate Representative Scott's comments about his actions at the magistrate level. And is that something that you're seeing that as a condition of bail is happening more and more often? Thank you.
Representative Krupo, it's a great question, and I think the strongest incentive we can offer veterans in the system to undergo these therapeutic interventions is the opportunity to avoid a criminal conviction. In this modern day, a criminal conviction is the modern day scarlet letter. Computer, digital criminal records follow people around like never before, and particularly in felony offenses, make them a permanent second-class citizen. And for veterans who are already struggling to reintegrate back into their communities, that conviction can be one more and often the major straw that breaks the camel's back of preventing them from reintegrating back into their community and fulfilling their full potential. So certainly the opportunity to avoid jail and prison time, but the opportunity to avoid a conviction, in my experience, having represented thousands of veterans now over 26 years, that opportunity to avoid a conviction and to be a full citizen in their community is a powerful incentive for them to take accountability for themselves and undergo all of the intense requirements of these therapeutic intervention programs.
So, to play devil's advocate, in the instance that they are otherwise ARD eligible, that is their opportunity to do far less, have a lot less therapeutic involvement, and maybe that's a rarity, but is there something that we could be doing in that particular situation to encourage people? Because what I would like to see is that we get these people, our heroes, the treatment that they need initially, so it's not a second time around when they're facing jail time, that they actually get into the treatment court that they need.
It's a great question. And I think there is a struggle when you're talking about lower level offenses where there are diversion opportunities available to them that don't require as much heavy lifting. That's a challenge. In my own personal experience with my clients, I often, talk to them and say, look, the legal incentives aren't that different here, but these additional programs that we're looking to have you go through may well save your life and save your family. And they don't always take the bait, but more often than not they do, and they benefit from it.
Thank you.
Thank you, Representative. Mr. Tate, did you have something on this quickly?
The briefest of brief comments. What matters most to the veteran in your court is actions, not words. Services, peer support, compassion, and standards. They need to know that you do have standards, that you will not let them fall below. If you demonstrate all of those to the veteran, he or she will respond to you.
Representative Pielli.
Thank you, Mr. Chairman. I want to first thank all of the panelists for their dedication and service to our veterans. As an Army veteran myself, who's suffered from depression and who's later represented as an attorney many veterans during the course of my career. I think one of the most important things is educating not only our law enforcement, some of our judges, and probation and others that are involved in this. My experience before Chester County had a veterans court was very frustrating. I had a person who was deployed 3 times as a major, who came back and had some obvious problems of PTSD. To friends and family, his personality totally changed to a very unlikable person who was previously a very well-liked person. Infidelities, substance abuse. He eventually checked himself in after his 3rd employment to the VA. Eventually got a pass, went to a friend's house, and took a 9mm and came back to the VA. Sat in the parking lot and was about to do himself in, but he, on the dashboard, had a picture of his 2 daughters, and he decided this isn't a good idea. Put the weapon underneath his seat, got back into the VA, Of course, the friend was concerned, found out his weapon was missing. He called the local police. And their reaction was very surprising to me. They had to do what they had to do. But one, the VA gave up jurisdiction, which I didn't fully understand. Two, the charge was theft, theft of the gun, and also carrying without a license or permit, et cetera. And they were going full speed for a prosecution. Eventually, I met with the VA. We didn't have a veterans court. We had a mental health court. So I said, listen, this guy is suffering from PTSD. All the indicators are, and they didn't want to hear it. You know, their image of a veteran, a wartime veteran, even though many of them might have been wearing yellow ribbons in the past, that didn't fit their image, warts and all. And that's what war does to people. And I think the more that law enforcement, our judiciary, some judges got it, some judges didn't. Luckily, we had a Vietnam veteran judge at the time. He got it. He understood that my client slept with a loaded weapon under his pillow, hypervigilant. While we were negotiating to get him into mental health court, we were told by the DA that he believes that he's faking it. That was actually previous DA, not the great DA we have now. And I had in my briefcase the recent VA disposition that he was 100% disabled, PTSD. And I put that on the table and I said, you can pick a jury. I'm ready to go. Eventually, they made a deal. But without educating everyone involved, and I agree we have to get the community too, they have to be involved to understand what these special circumstances are and what our veterans are facing, their unique challenges that they have, and the repercussions of their service. So thank you for all that you're doing. And any way I can help, I'll be there. Thank you.
Representative Peeling, I echo your sentiments regarding the importance of education and training. The model policy framework puts an emphasis on the need for educating criminal justice stakeholders. Understanding these issues and how the system can be used as an intervention tool is maybe one of the most important aspects of this. Just that knowledge and awareness of how to use the system, it goes a good portion of the way.
Mr. McEwen, you had something?
Well, I was going to add that one of the things the Veterans Justice Commission looked at was there are opportunities where we know that certain jurisdictions look at veteran service as matters of, instead of as matters of mitigation, matters of extenuation. And they look at it as something that you're a trained killer instead of you maybe have got something that has occurred during your service that should be considered. And so we looked at that and made some recommendations for jurisdictions to consider your service.
Thank you. Others? I think we only have time, Representative Bonner, for one round here. Chairman Kaufman, did you have anything? Chairman Gillen.
Since Montgomery County is a coin of the realm, I used to work in Montgomery County at one point in my life. Mission impossible for the panel, since the role of mentoring is so important regarding guidance, navigation, accountability. Just a one-word response from each of you, if you like. Do we have enough of them?
So, sir, the question is, do we have enough mentors?
Yeah.
No, sir. And it's not just the number, it's who they are and who they represent. Do you have your female mentors? Do you have post 9/11 mentors? And I'll stop at that, but I think you see what I'm saying. Thank you.
Probably we do, we just don't know who they are or where they are and haven't trained them.
I would have the same answer. We don't have enough on the lines in the courts. There are plenty of them out there in the communities who could validly serve that role really well. We need to find them, recruit them into the process.
And again, training is, again, a best practice. The training of the mentor and how, not just being a veteran themselves, but delivering the goals of recovery and mental health. And as to the one overriding question people are talking about here is, I'll just throw it out there, DAs, judges, they need to become trauma competent. That's where everything is at now. In drug court, veterans court, mental health court. Trauma competency in a court system is a way in which we all can move forward in this subject.
Thank you, Mr. Chairman.
Thank you, Chairman Gillen. On this point, to identify mentors, to identify veterans who are in need of treatment, we here in Pennsylvania constantly struggle to figure out where our veterans actually are. We've thrown different policy prescriptions at this, like the Veterans Registry, My Bill, Vet Connect, all have failed. What are other states doing? I guess this is to you, Mr. McEwen. What are other states doing to identify their veterans population that we in Pennsylvania are not?
I'm not going to say what Pennsylvania is not going to do or hasn't done. I will tell you a couple of things. First, the VJC asked NYU to do a study on veterans, justice-involved veterans in our prisons, because we've asked that question. How many veterans are incarcerated? And that's a question that no one can answer very easily. So we asked how many veterans are in Pennsylvania jails and prisons. Pennsylvania reports in 2023, 2,462 veterans in your prisons and jails, or in your state prisons, which is 6.5% of your population. We asked how did that get, and that was roughly that method was self-reporting according to the Commonwealth, and it represents 6.5% of the population. And we believe that's probably an under-representation of your veteran population that's incarcerated. And we found that along a lot of states. And that's because we know that those two VA databases that are available, VRSS and Squares, are woefully underutilized. Some jurisdictions use them very well, but most jurisdictions who care a lot do work hard, like Montgomery County does, to try to identify veterans. But using the databases that are available, the utilization rate's less than 10%. More and more jurisdictions are trying to do it, but that's one of the recommendations that we have, is that we really need to do a better job of using the databases that are available from the federal government and incentivizing the use to identify veterans.
Thank you, Mr. McEwen. Mr. Tate, on eligibility, this seems to be a tricky one. If you could identify a model for us here in Pennsylvania. Mr. Hunter, it seems like changing sentencing will be something that folks resist, DAs, certain people in law enforcement. How have you best navigated that to bring them into that conversation? And Judge, when you first communicate with with a veteran, eligibility has been determined. I'm just wondering how intentional you are in that first conversation, meaning is that done outside of the courtroom context? Do you take them into chambers? Do you take off the robe? What is that dialogue like? So first, Mr. Tate.
Thank you. I can tell you how interested judges would be in us dictating to them a model of eligibility for the courts, and that would be not very interested. So we suggest a number of approaches because we want to defer to the states and the court systems as they know what's best for their commonwealth, for their state. That said, I have opinions. For example, you really miss an opportunity if you exclude from your population of those eligible those who with bad paper. Have we ever taken a moment to step behind that bad paper and ask why? Maybe it's that underlying behavioral health issue. Maybe it's military sexual trauma. Maybe it's substance use disorder, trying to deal with those other issues that cause that individual to engage in poor behavior resulting in bad paper. So I'd simply urge serious and informed discussion on eligibility when the issue comes down to PTSD, or better said, when it comes down to bad paper.
Thank you.
Thank you.
Mr. Hunter.
Eligibility really is the key issue here. From our perspective, my perspective, eligibility should be as broad as possible to maximize the intervention opportunity we have when a veteran falls into the system. This is a unique chance to leverage them in to the treatments they need and see their way through it. I think we should take every opportunity that we have. Yes, prosecutors and law enforcement often are resistant to these ideas initially, but over many years, I have brought many of these folks around to seeing things in this way, recognizing that these veterans without a proper intervention opportunity or therapeutic intervention opportunity continue to be dangerous to public safety. Treating them in a punitive way does not solve their underlying issues, does not deter future bad behavior, and as we saw with the Vietnam veteran generation, all too many of them end up in cycles of recidivism, continuing to act out against their communities and continuing to come through the system.
We got to move to Judge, 5-second answer.
Yeah, it's, again, you just can identify the vet in veteran treatment court when you don't have robes on, you're sitting across the table. Your idea is, I have large groups of people when we call lists. I identify someone as a vet, I take my robes off, I go down, I shake the person's hand. I've already begun an optics to say, yeah, we're going to look to see if we can treat your outcomes different. Thank you.
Thank you, Judge. Thank you, panelists. Thank you, members. This joint hearing is adjourned.